Welcome to From Our Perspective. Today, I'm joined by probate partner Liz German to discuss a case where our client's ex-spouse passed away unexpectedly with an outdated will. Liz helped a mother protect her home and keep money originally meant for child support. Liz, thank you so much for joining me today. Tell me more about our client and why she needed your help.
Our client initially actually came to us as a family law consultation, and they were tasked with helping her collect on some past due child support. And they effectuated a judgment, but unfortunately, before our client could be paid out, the person who owed that money to her passed away, which implicates the inability to transfer funds without proper court procedures. So because we have a probate department, we were able to be given that information from our family law attorneys to be able to help her initiate a probate proceeding to be able to collect that money. That was one issue. The other issue was the client really needed to ensure that her minor daughter, who should be the sole beneficiary of her late father's estate, was able to collect that money, and there was a concern with family members causing issues with not providing assets or disclosures. So we were able to be given that case and then help her effectuate both goals of both the collection of those monies owed to her and protection of assets for her daughter.
So as you mentioned, our client also worked with our family law attorneys. How were you able to collaborate with our family law team in this situation?
The interesting thing about that is they weren't even in the same office location, but we have a collaborative community where we can pick up the phone, send emails, all of our databases match, where they could just send us information and we could look at it and then address the needs of what they needed help with without actually ever having to meet, which caused the client to not have as much time and energy spent with having to schedule multiple appointments. We were able to, within a few days of them presenting the problem to us, meet with the client and establish what needed to be done to help her in the probate.
And what were some of the challenges our client faced by the ex-spouse's parents in this situation?
There were things like cars. There was actually a home that we're going to need to be given to the proper heirs. They unfortunately believed they were the proper heirs, so they weren't providing any information to our client. They unfortunately didn't even notify our client to allow her daughter to know that the father had passed for almost 2 months. So there was a lot of lack of communication, non-transparency, which obviously caused our client concern that her daughter rights weren't going to be protected.
What was the best strategy to make sure our client received the maintenance and the child support that she needed?
We had a couple of different legal strategies. Initially, we believed that we could open a probate because nobody else had up to that point for the client as a creditor. There's limited ways in which to open a probate. You have to have certain statutory standing, and unfortunately, as an ex-spouse, she didn't possess that, but she did because she was owed that money as a creditor and no one else had filed. Throughout the process, we actually came across another legal argument to bolster her case to be appointed in the fact that she was the sole guardian of the only heir of the estate. So she kind of had a couple of different legal arguments that we could use to ensure that she had the strongest position to be appointed to be in charge of the estate, to both collect her own money and then again, make sure her daughter got hers as well.
And ultimately, what was the outcome of this case?
The initial petition that we filed was competed with by the other family members who purported to bring a will into the equation, arguing that they should have been the beneficiaries. And we were able to argue a law that says if a child is not contemplated at the time a will is entered into or otherwise provided for, called the afterborn child statute, that they then get what estate there would be under the law if that person didn't have a will. So we were able to negotiate a nice resolution where our client maintained control. We actually still accepted some of the conditions from the other side to ensure that the money was being managed, because that was a concern they had, obviously being an ex-spouse, that the child's interests were being protected. We were able to actually pull in another area of our team, the estate planning, and set up a minor trust. And so ultimately our client got her money by being appointed. Her child got her inheritance, and it's set up in a protected way that ensures her daughter's future needs are going to be met.
And what advice do you have for someone who is dealing with a complex situation like this involving both an estate and family law issues?
Talk to a licensed professional. There are always nuances to every case. Trying to do it on your own when you have a lot of those issues, especially with family, tend to get murky. So removing yourself from that stressful situation and letting someone else step into the shoes of being able to be your advocate is always great. We offer consultations where we can give guidance to get you on the path to the legal help that anyone will need.
Great advice, Liz. Thanks for sharing your perspective.
Not a problem. Thank you.
If you are facing a situation where a loved one has passed away with an outdated will, it's important to take action quickly. Reach out to us for a case assessment on our website or give us a call.